Welcome back to the Deep Dive. Today we are tackling a cornerstone of civil law, something that affects almost everyone. We're doing a deep dive into the tort of negligence.
It really is everywhere. It's basically the law's way of giving you a remedy when someone's carelessness, their failure to take proper care, causes you injury or loss.
And the whole system hangs on one core question, right?
It does. It all boils down to, ought the risk of harm to have been foreseen?
So if you're bringing a negligence claim, you've got to clear 4 massive hurdles. You trip on one, and the whole thing falls apart.
That's right. You, the claimant, have to prove 4 things. First, that a legal duty of care was owed. Second, that this duty was breached.
And we'll cover the other 2, causation and damage, in a future deep dive. But for today, we're focusing on just those first 2.
Duty and breach. They are the absolute foundation.
Okay, so let's ground this with a really simple example. Let's say Laura knows she's had too much to drink, but she gets in her car anyway, she loses control, and bam, crashes right into her neighbor's parked car.
A classic and a very clear-cut case. If the neighbor sues, those first 2 hurdles are cleared almost instantly.
How so?
Well, first, duty. As a driver, Laura automatically owes a duty of care to every other road user. That includes pedestrians, other drivers, and yes, people with parked cars. So duty is established, tick.
And the breach.
Even easier. The standard is that of a reasonable, competent driver. Driving drunk is obviously falling well below that standard. So breach is also established. Hurdles 1 and 2 are cleared before the tow truck even arrives.
But it's almost never that simple, is it? Let's dig into that first hurdle, establishing a legal duty of care.
Right. So the basic definition is it's the legal obligation you have to take reasonable care to avoid causing harm to someone else.
And in a lot of situations, like with our driver Laura, that duty is just there. It's automatic. The courts call them established categories.
Exactly. It makes things much easier. We're talking about doctor to patient, employer to employee, teacher to people.
Road user to other road user.
And crucially, manufacturer to consumer. And that last one is probably the most important legal development of the last century.
Which brings us to the case that everyone learns in law school. The snail in the bottle.
Ah, Donoghue versus Stevenson, 1932. It's the genesis of modern negligence law.
So, set the scene for us.
Okay. Mrs. Donoghue goes to a cafe. Her friend buys her a bottle of ginger beer. The bottle is dark, opaque glass, so you can't see inside. She drinks some, then pours the rest out. And with it comes the decomposed remains of a snail.
Ugh. And she gets sick, so she wants to sue the manufacturer. But there's a problem.
A huge problem. She didn't buy the drink, her friend did. So she had no contract with the manufacturer, Stevenson. And back then, no contract usually meant no lawsuit.
But the court made a huge leap.
A monumental one. Lord Atkin, in his judgment, came up with what we now call the neighbor principle. He said, you owe a duty to anyone so closely and directly affected by my act that I ought reasonably to have them in contemplation.
So it's not just about your literal next-door neighbor. It's anyone you could foreseeably harm.
Precisely. Suddenly, the manufacturer in his factory owed a duty not just to the shopkeeper he sold the drink to, but to the ultimate consumer, Mrs. Donoghue. It changed everything for consumer protection.
Okay, so that opened the door. But the courts then worried it had opened the door too wide.
Right. They needed a way to control the flow, especially for new or novel situations where there isn't an established duty.
And that gives us the modern test, the 3-stage test from Caparo versus Dickman.
Yep. This is the filter the courts use today. And the claimant has to satisfy all 3 parts. Step 1 is reasonable foreseeability.
Was the harm a predictable outcome?
Exactly. Was it foreseeable that exposing children to asbestos dust would cause illness? Yes. But in another case, was it foreseeable that a bystander who only saw the aftermath of a crash would suffer psychiatric shock? The court said no. Too remote.
Okay, so if the harm is foreseeable, you move to step 2, proximity.
And this isn't just about being physically close. It's about a legal closeness, a connection between the 2 parties.
Like what?
Think about the case with the British Boxing Board. The court said the board had proximity to a boxer who was injured because the board controlled all the safety and medical rules at ringside. They had a direct relationship of control.
Foreseeability, proximity, and then the big one, the policy-based escape hatch.
Step 3. Is it fair, just, and reasonable to impose a duty? This is where the court looks at the bigger picture.
And sometimes they just say, no.
They do. A famous example is a case about a failed vasectomy. The parents sued the doctor for the cost of raising a healthy but unwanted child.
So pure economic loss.
Pure economic loss. The court decided it just wasn't fair, just, or reasonable to extend a doctor's duty to cover those costs. They said the joy of raising a child couldn't be calculated as a financial loss. It was a policy decision.
So even if you can foresee harm and you have proximity, the courts can still slam the door shut if they think it's bad policy.
That's the power of the third step.
Okay, let's talk about some really difficult duty situations. First up, omissions, failing to act.
This is where law and morality can feel very far apart. The general rule in law is strict. There is no positive duty to act.
So the classic example, you see someone choking in a restaurant, you're a doctor, and you just walk past. Legally, you're in the clear.
Morally, it's terrible, but legally, yes. The law is very reluctant to compel people to be good Samaritans. In one case, a council failed to remove a dangerous bank of earth on a road that caused accidents. The court said having the power to fix it didn't create a legal duty to pay compensation when they failed to.
What, there have to be exceptions?
Oh, absolutely. There are 3 key ones where a duty is imposed for an omission. First is control.
Meaning you have control over the person who causes the harm.
Or the person who is harmed. A school, for instance, has control over its pupils. If they let a small child run out into the road and cause a crash, the school is liable for its failure to supervise.
Makes sense. What's the second?
Assumption of responsibility. This is where you voluntarily take on the job of looking after someone's safety.
Like the military case.
The very one. A naval pilot got extremely drunk. His superior officer ordered him to be taken to his bunk. They assumed responsibility for him, but then they left him alone, and he tragically choked on his own vomit. The Ministry of Defense was held liable not for letting him drink, but for failing to watch over him after they'd taken charge.
And the third exception.
Creating or adopting a risk. If you start a fire, you have a duty to put it out. But also, if a fire starts on your land by, say, a lightning strike, you have a duty to take reasonable steps to stop it from spreading. You've adopted the risk.
Okay, what about when the harm is caused by a third party? A criminal, a vandal.
Again, the general rule is no, you don't have a duty to prevent other people from causing harm. In the Littlewoods case, a company bought a derelict cinema. Vandals broke in and started a fire that damaged the next-door building.
And the owners weren't liable.
No, because they had no reason to foresee that kind of deliberate criminal act. It wasn't on their radar.
But again, there are exceptions.
Of course. If you have a special relationship with the claimant, say you're a decorator and you leave their house unlocked, you're liable when a burglar gets in. Or if you have a special relationship with a third party, like you're supervising young offenders who then cause damage.
And if you create the danger yourself.
Then you're on the hook. The classic case is leaving horses untethered on a busy street. When some kids threw stones at them and they bolted, causing an accident, the owner was liable. He created the source of danger.
Still, the courts seem very hesitant here.
Extremely. Look at the Mitchell case. A council had a heated meeting with a very aggressive tenant. Immediately after, he went and killed his neighbor. The court said the council had no duty to warn the neighbor. Imposing that kind of duty was just seen as too great a burden on public authorities. It's another policy decision.
Okay, let's assume our claimant has made it. They've jumped hurdle 1, they've established a duty of care, now they hit hurdle 2, breach of duty.
Right, and this is all about measurement. Did the defendant's conduct fall below the required standard of care? The burden is on the claimant to prove it was more likely than not. 51%.
And the standard is objective. It's not about what that specific defendant thought was reasonable.
No, we compare their actions to the famous reasonable person, or, as the old cases put it, the man on the Clapham omnibus.
Your average, everyday, sensible person.
Exactly. He's not overly anxious, but he's not reckless either. He's just reasonable. If what the defendant did was something this reasonable person might have done, there's no breach.
And if something is completely unforeseeable, a reasonable person wouldn't guard against it.
That's the key. Think of the case with the water main that burst in a massive, unprecedented frost. The water company had taken precautions based on all known temperatures. They had acted reasonably. They weren't liable for an act of God.
But the court looks at other factors too, right? It's not just a simple yes or no.
They have to weigh a few things up. First, the cost of precautions. If a very simple, cheap precaution could have prevented the harm, a breach is more likely.
Like putting up a wet floor sign.
A perfect example. But in one factory case, the floor was flooded and slippery. The owners spread all the sawdust they had. The only other option was to shut the entire factory down. The court said that was a disproportionate cost. What they did was reasonable.
Then there's the social value of what the defendant was doing.
Yes. If the activity is socially important, the standard might be slightly lower. Think of a fire engine rushing to an emergency. The risk of a traffic accident is balanced against the urgent need to save a life.
That doesn't give him a free pass to drive recklessly, though.
No, but context matters. Then you have to look at the likelihood of harm. How probable was it that an injury would occur?
This is the cricket ball case, isn't it?
It is. Bolton versus Stone. A cricket ball was hit out of the ground and struck someone on the street. But it was a huge hit, and this had only happened maybe 6 times in 30 years. The risk was so small that the court said a reasonable person wouldn't have built a higher fence. No breach.
But you balance that against the seriousness of the injury.
You have to. If the potential harm is catastrophic, you need to take greater precautions, even if the risk is low. In Paris versus Stepney Borough Council, the claimant was a mechanic who was already blind in one eye.
So any injury to his good eye would be devastating.
Exactly. Total blindness. The risk of a stray metal splinter wasn't high, but the consequence for him was so severe, the court said his employer breached its duty by not providing him with safety goggles.
Now, what happens when the defendant is a professional? A doctor, an architect?
Yeah.
The standard changes.
It does. You're no longer judged against the man on the bus. You're judged against a reasonably competent professional in your field.
And being a beginner is no excuse.
None at all. A learner driver is judged by the standard of a competent driver. A junior doctor is judged by the standard of a reasonably skilled doctor in that post. The public needs that protection.
And for doctors, the traditional test for treatment was the Bolam test.
It was. It basically said a doctor isn't negligent if they've acted in line with a practice accepted by a responsible body of other medical professionals. In other words, if you can find a group of your peers who agree with what you did, you're probably safe.
Which sounds like doctors marking their own homework.
It could be, which is why the courts added a gloss to it, the Bultho modification. The court said that the medical opinion has to have a logical basis. It can't just be something a few doctors believe without any rational defense.
But the really big change came with warnings and patient consent.
A huge shift. This is the Montgomery case. It completely changed the dynamic.
So Bolam was about what doctors think is important. What's Montgomery about?
It's about what the patient would think is important. The focus moved from medical paternalism to patient autonomy.
So it's not what would a reasonable doctor tell their patient.
It's what would a reasonable patient want to know to make an informed decision. A doctor now has a duty to disclose any material risk.
And what's a material risk?
A risk that a reasonable person in that patient's specific position would likely attach significance to. In the Montgomery case, a diabetic mother wasn't warned about a tiny but specific risk during childbirth. The risk happened. The court said because that risk was material to her and her choices, it should have been disclosed.
Okay, what about other special groups?
Children.
Children are judged against other children of the same age.
Yeah.
So when 2 15-year-old girls were fencing with plastic rulers and one got hurt, the court said, you have to ask what a reasonable 15-year-old would foresee. And they wouldn't foresee that risk. So no liability.
That seems fair. So we've worked through the standards, but how do you actually prove the breach happened? Sometimes it's obvious, sometimes it's not.
Right, and when it's not, the claimant can sometimes rely on a legal doctrine called res ipsa loquitur.
Which means?
The thing speaks for itself. So the accident is so strange that negligence is the only logical explanation.
Pretty much. 3 conditions need to be met. 1, the thing that caused the damage was under the defendant's control. 2, the accident wouldn't normally happen without carelessness. And 3, we don't know the exact cause.
Give me an example.
A barrel falls out of a warehouse window and hits someone below. We don't know why it fell, but barrels don't just fall out of windows on their own. The very fact that it happened speaks for itself and points to negligence.
A useful tool. And there's one more thing that can help the claimant. A criminal conviction.
The Civil Evidence Act. If the defendant was, say, convicted of careless driving for the accident, you can use that conviction in your civil claim. It flips the burden. The defendant now has to prove they weren't negligent, which is much, much harder.
So we have successfully navigated the first 2 hurdles. We've established a duty of care, and we've shown how the courts determined if that duty was breached.
We've gone from the snail in the bottle, which created this massive sphere of consumer protection, all the way to the fine-tuning of the reasonable person standard for everyone, from a bus driver to a brain surgeon.
Let's end on a thought then. We talked about that 3rd stage of the Caparo test for new duties, the part that asks if imposing a duty is fair, just, and reasonable.
It's the most controversial part, but also maybe the most important. It's where pure law meets public policy.
It seems to introduce a level of, I don't know, social engineering into the law. The courts are making value judgments.
They are. And here's the question for you to think about.
Hmm.
How much should the law be focused on protecting public bodies, like the police or a council, from being sued into inaction? This idea that they might become too risk-averse if they face liability for everything.
And how do you balance that against the individual who has suffered a very real, very foreseeable harm because of that body's carelessness?
That's the constant tension. It's a balancing act between individual justice on one hand and the wider public interest and practicalities of running a society on the other. And that tightrope walk is what truly defines the boundaries of modern negligence law.